All right, we're good to go.
All right, so I'll read the conflict statement and we can get started. So members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any manner coming before this committee with respect to which there is a conflict of interest. Welcome, everybody. I hope y'all had a good holidays, good New Year's.
Hope you did as well, Davis.
Too short, as always, but well, Brian sent out the revised opinion in earlier this week, and he and I were speaking before this meeting just briefly about some thoughts. And I think after the October committee, there was a lot of people concerned about this subcommittee and this issue. At least some people voiced their concerns about it and told us not to screw it up, pretty much. is what I got. But I guess we could start opening the floor to comments to the revised opinions. Or Brian, would you like to start? I think it might be worth floating what you were just talking to me about and let everybody kind of process that.
Yeah, well, and I'll kind of just give the quick recap of what that revised opinion is. You know, the revised opinion basically switched the inquiries. So we lead with the one that I think was the most obvious scenario. That's a no-no. And that is showing up at court for 4 different clients and trying to bill 1 hour to each of those 4 clients, even though you're only there for 1 hour for the total. So that one I think was the more obvious one that we all agreed. You know, there's no question you can't do that. Excuse me. Number 2, of course, being the one that I think we discussed the most and the one that got a lot of feedback in October, the travel situation where a lawyer's traveling and doing work or traveling for one client while doing work for another client. Can you bill travel hours as well as work hours for the legal services that you're providing to these different clients? And the answer in the proposed opinion is no. You see, it's kind of a truncated version because we flip-flop the opinions. You know, just kind of saying that essentially you're overlapping your time, and that's something that you're effectively, in the scenario presented in the opinion, you're billing 7 hours for work or 7 hours of work that occurred in 4 actual hours of time, and that's just something that is not possible under our rules. The third opinion is a new opinion regarding unit billing. It's a very short opinion that simply clarifies or distinguishes if you're billing in units, that is permissible. You know, even if you have a unit, you don't like the scenario presented is you spend 3 minutes, you bill in units of 6 minutes, 0.1 hours. You spend 3 minutes responding to an email, and then another 3 minutes responding to a different email for a different client. Each one of those actions under your billing agreements, your fee agreements, would allow you to bill for 1 unit. Is that permissible, or are you now billing for overlapping services? And the opinion distinguishes that particular scenario from the other ones by saying that, yes, you're allowed to do that. You're allowed to bill those separate units because you've completed separate legal services, separate legal tasks to or for these different clients. It's outlined in your fee agreement, made very clear, and it's not clearly excessive. So it kind of preserves that process. I'm going to pause right now. We have a call-in user. I wanted to identify this person that's joining by telephone. Oh, that's you, Bill. Okay. Okay, just want the sound isn't working. All right, that's good to know. So that's the revisions. Opinion number 2, or inquiry and opinion number 2, the travel scenario, is the one that I think we need to continue to focus on the most, because like Davis said, we had a lot of feedback at the October meeting, and I've talked to some folks even after the meeting about their concerns about this opinion. And to be clear, it's not so much, it's kind of a mixture of concerns and questions, and just kind of almost like it really embraces the evolution of practice and what we can do in society. I think one of the things that was posed to me was this notion that if you are traveling, let's say you're traveling by car from point A to point B. It's going to take you 3 hours to get there. And you're doing it in the middle of the day, and you're doing it for client A. If client B calls and says, I need legal advice right now, the prohibition, or at least I guess it's not prohibition, it's the requirement that you can't bill full amounts for these overlapping services, right? So you have to prorate your services. That essentially, in that scenario where lawyer is driving for client A and client B calls with a need for immediate legal advice, now lawyer is in this position of trying to almost calculate on the road, what am I doing? Okay, now I need to half my fee, or maybe I get to my location. I have to half my fee for those 20 minutes that I was on the phone, or 25 minutes, whatever it may be, or I just have to give free legal advice and not charge because it just becomes too much of an administrative nightmare to actually track all this stuff. It was, I guess, that in that scenario is kind of posed to me that, it's really kind of creating a disincentive for lawyers to be attentive to their clients. And while I don't know that a lawyer would really just refuse to take the call, but I still see the point. Where are we creating a burden on lawyers and providing legal services? Not to mention, one of the other things that was posed to me is just that travel and working during travel is simply different these days. It's so possible and so easy to have your office with you wherever you go, to be on the phone safely while you drive to a deposition for a different client and be able to attend to those client matters. And so I think we have this, with that particular opinion, the travel opinion being the one that was kind of generating the most conversation. It seems like Davis and I were talking, it seems like there's maybe 3 options. One is to take inquiry and opinion number 2 out and just not address it, which probably isn't going to be helpful because people are going to ask the question. Second is to leave it as is in the opinion, which is, again, that's overlapping services, you can't double bill. And third is to perhaps explore a different line of thinking that I was mulling over. And I want to be clear when I say this, I don't know how I really feel about this analysis, but I want to get your thoughts on it. Because this is something that no other state has said. But it occurred to me when I was looking at some of these old opinions and kind of the crux of the issue has always been the provision of legal services, overlapping legal services. And the thing that I want to ask you all for feedback on is, truly, is there a distinction between legal services and travel services? Can both be accomplished at the same time in 2023 in a way that is not misleading to clients, in a way that is not clearly excessive? Is it something that this opinion could actually answer the question? Yes, you could do that. You can bill for travel and you can bill for legal services, because the issue, the principle, the harm that the rules were focused on is a lawyer providing legal services to client A while simultaneously providing legal services to client B. That's what the lawyer really is retained for. And when you're providing legal services of the same nature, really the exact same service to 2 separate clients and billing them the full amount, that's the misleading, that's the dishonesty issue. And the clearly excessive issue. But if you're traveling for client A, you can complete the task that client A has asked you to complete. That is travel from point A to point B, while also simultaneously providing legal services to client B. And you can do that without any sort of detrimental impact to the travel services you're providing to client A, nor the detrimental impact to the legal services you're providing to client B. That essentially both clients can get the full services that they are paying for. Is that an alternative analysis? Do we feel like that's something we should actually put down on paper and explore? Do we not feel comfortable with that? Are we splitting hairs? Things of that nature. So I feel like that's a third option, and maybe that would be a good place to start our conversation.
Jack, go ahead.
Yeah. So one of the things that I have found is, the longer you're on the State Park Committee, the more people know it, and the more you will get people contacting you wanting to share their opinions, which in a way is really good. So I've talked to a number of people since we talked about this last. And where I am right now is I wish we could formulate an explanation for what you just said at the last part of what you just said right there, which is that the reality of life in 2023 with the technology we have is not injurious at all to the populace, to our client base, for us to be able to handle a phone call when I'm driving to court in Duplin County. I think it would be ideal if we could do that. But where I am right now is that when I keep wrestling in my mind with different ways to say that in a way that will not be perceived as offensive by the general population, it becomes much more difficult. I think it's the right way to think. I think it's the more progressive way of taking into account the changes in technology. But I think it's very difficult to say, to articulate in a way that is reasonable. And so where I kind of come down is, and I will tell you, I've probably spoken to a half a dozen people who have all basically said, please don't address this, because I have found a way in my life that I am ethically okay to do this, that my clients are getting my best service, and they are certainly not being injured in any way. But if you try and formulate that, you guys are in trouble. So where I am right now is I wish we could do that, but I kind of like the idea of putting 1 and 3 out there and maybe not touching 2, although I'm totally open to doing 2 and wrestling more with the language. I will tell you, I have thought a bunch about this, and it's a toughie. It is a toughie. I think, so I'll shut up now, but I think my point is just simply that I think Brian is right. I shouldn't say that. You didn't say you were advocating that position. I think that sentiment is right. But I think if we do try and formulate that, or we do try and articulate that, we better be really darn careful, because it's a potential minefield.
Yeah, I think I got the same feedback from the October meeting. Don't regulate what we don't need to regulate.
Yeah. Right.
I think that Brian did a good job. I think one thing that he added in this that may not have been in the other part, the first opinion, was that this does not apply to flat rate billing. So that's something we're not regulating, is flat rate billing doesn't apply. Unit billing now has a carve out that, again, it goes back to our 2-part theory. You've got to have it in your fee agreement as to how you're billing, and then it can't be clearly excessive. And so that's our kind of our 2-part analysis here. And unit billing, it doesn't apply to unit billing if you're doing it correctly. And then, so I do think we're on this travel issue. And Brian, I don't know if it's worthwhile, I'd like to hear from everybody else, but it might be worthwhile for us to put our heads together and try to put something in writing so we could see what it looks like. Do we want to bring this thought up to the full committee next week? Because that might take a lot of time up in the meeting. I mean, people are going to have some thoughts on this, and it might be good to hear from them. But do we want to suggest that before we have anything in writing? Maybe, I don't know.
Yeah, I'd like to hear. I thank you for those comments, both Davis and Jack, and I think I'd like to hear the other subcommittee members, see if what you think of that alternative approach, understanding that, like I said, no jurisdiction has said this, so it would potentially make waves. I have to also add, just as a context, something that one of our other counselors had pointed out to me, that it was, I think they were talking about insurance companies have started cutting their travel rates that they will pay to lawyers. And the reason being that the reasoning that was provided to this counselor was that the insurance companies feel like, well, you're working for other clients while you're traveling anyway. So why am I paying your full travel rate? We're going to go essentially that the insurance companies were effectively doing what the original opinion was said that lawyers are supposed to do. They were just cutting it. They were prorating their rates. And so, it's that thing of, to your point, Jack, I fully appreciate what you said about it seems like the right thing, but how you put it down in writing starts to sound like we're just a self-serving bunch of jerks. And I guess to borrow from the Carolina Hurricanes. And that's something that, I wrestle with, but I wrestle with that, but I also recognize, kind of similar to the confidentiality issue that we dealt with last year with a rule amendment that allows lawyers to talk about stuff that's in the public record, even if they don't have client consent, if we're talking about a former client. And one of the things that we discussed in the ethics committee meeting when we were going back and forth on that was, what clients think that you can't do this? What clients think that you, lawyer, cannot talk to someone else about, if they come up and say, hey, I heard that you had a great cross-examination in that case. Can you tell me about it? What clients think that lawyer is not able to say, well, let me tell you about it? Instead, they're supposed to say, no, I can't talk about what happened in a public hearing. It's kind of a practical reality. And I wonder similarly where this falls. If this is something that the public generally kind of anticipates, like the insurance companies are already putting into action, lawyers are doing work while they're traveling, and maybe they're not terribly offended by that because of where we are in 2023. Maybe it was a different situation 30 years. I mean, it was a different situation 30 years ago, and maybe it was a different impression. And that's not to say that just because, it's like we don't, the notion of, well, we don't want to regulate something that doesn't need to be regulated. I mean, if there's a practice going on that actually does violate the rules of professional conduct and we can offer some clarification, then we should do it. But I just wonder if this is one of those things where maybe it's not so much like we don't want to screw it up, but if this is something that folks are not, the public is not surprised by and or offended by, is that something that we just need to set out the parameters for and create that distinction? I don't know. I've said a lot of words. I'd love to hear Catherine, Bill, Lamar, what do y'all think?
I'm just drawing circles. I don't have a great answer. I guess I'd prefer kind of not to get in the weeds about it. I don't know. It does sound like we're a bunch of sort of weasels protecting ourselves, which is not the goal. So, I mean, that's what I keep coming back to. But then I also had heard from several lawyers who are at larger firms with big corporate clients that this was the standard practice. And so part of me thinks, yes, we should address it, but I don't know. But I also have a default of, sometimes not saying anything maybe is better at this point, but I don't know that that's helpful, but those are my immediate sort of impressions.
Can I add really quick? One option that I didn't say is that we don't necessarily have to adopt an opinion. This was brought before us, and I think it's, you go back and forth on the utility of this opinion and the opportunity for clarification. I don't want us to stick our head in the sand on something because it's difficult or because it's going to make other people mad. That's not why we exist. We exist to protect the public. But if this is something that is not in need of clarification after looking at it and talking through with folks, that there's practices that are going on that query whether or not they really do violate the rules of professional conduct, but that they're not really causing client harm. Is that something that's necessary? We have withdrawn opinions before. We did that with the Google service ads just last year when we realized that the opinion that we originally drafted is just not something that's really helpful to lawyers. It doesn't match practical reality, and it's not really causing at least reported harm to the state bar. So that is an option. There is an option to just simply not publish and adopt anything. So I want to throw that out there too.
I think if somebody submitted this where our new inquiry number 1, I feel like we would be doing a disservice by not addressing that. That's pure dishonesty.
Well, these inquiries are really, this is inquiry of staff, because we have received questions, and really the crux or the origin of these questions was the law schools. It was something from one of the professors at a law school who contacted me and said, is there anything that we have addressing double billing? Because I've always understood it to be X. Other jurisdictions say X, basically say what our original opinion said. But there's nothing in North Carolina that says that. And I've got a lot of students that are just questioning and in disbelief that you're not allowed to bill for services while also billing for travel time. It just seems, like an obtuse sort of conclusion. And I have seen the same thing when I was teaching. I talked to Carmen Cannon. She's seen the same sort of questions. And we have fielded these questions on occasion. They don't come into the ethics hotline every day. And I think it's probably because maybe there's kind of an understanding of what is and is not okay. Whether or not that's correct is a different issue, or maybe it's kind of I'll ask for forgiveness rather than permission. But nevertheless, so I want to be clear on the origin really is from kind of a staff perspective, that this is something that has never been clarified, but we do get questions on, and so that's where we thought we'd put it before the committee.
Bill?
Sorry for the delay on my sound. Brian, you actually took the words out of my mouth with the idea of forgiveness versus permission. I am a ask permission guy. I'm sorry?
We got some feedback. I'm trying to figure out where it's coming from, Bill. Oh, now here, let me unmute your phone call. So I think you muted your microphone on Zoom. Oh, there we go.
How about now?
It's still got feedback. I'm not sure which one is. I think you've got 2 microphones coming in.
Yeah, unmute your phone and then mute your Zoom or your. No.
Now both are muted again.
Your phone's still muted. There you go.
How about now?
Perfect.
Sorry, I got all high-techy yesterday and somehow unhooked my mic, so I have double mics. I personally like permission as opposed to forgiveness. And for the record, I can't remember the last time I traveled and billed for it, so I really don't have a dog in the hunt. And part of the reason I think it's difficult and we're wrestling with it is that it needs to be addressed, and it's not a problem until it's a problem. And I think we talked at the last meeting about the attorney in Raleigh who went to prison for it for a relatively long time and got disbarred. And I think his was clearly excessive. He was billing more hours in a day or whatever. And I'm not the guy to write the language. I apologize to the bar staff. Y'all are the experts on that. But is there a way to do it simply to say that if you're traveling time, the resolution of this is that you set a reduced hourly rate, put it in your contract, set forth the fact it's a reduced hourly rate, understanding that you may be working on other matters at the time, and as a result, you're doing it as a discount. And then it's, we're done. We've put it out there. As far as worrying about people thinking we're greedy or we're trying to protect our own tails, that's what contracts are for. In my mind, contracts are set forth to avoid confusion on the subject, and clarify points, and making clients aware from the outset, this is what we do, this is a standard practice, and if you like it, that's great. If you don't, then maybe you seek alternate legal counsel, or maybe we talk some more about this. Because I think the elephant in the room is we know this is happening. We know that this is probably happening a lot. And when I hear people saying, I'm comfortable with the way it is and the way I've done it in years past, that makes me a little anxious. I would like a little bit more sunshine on the subject. So I think that's number two. The other ones to me are a little bit more straightforward. Maybe we present the first two and continue to study this issue and wrestle through and get done what we can get done and make some, advance the ball. I don't know. I'm not trying to be contrarian in here because I really don't build this way. But gosh, if I were with a big firm, I'd want some clarity on this myself. I don't know.
Bill, I thank you for that. I think that's, I think it's really practical. And I think that's something to me, like I said, it's what you described is what I understand to be the case, that most people charge a reduced fee for travel. I don't know if that's across the board. That's what I hear. I don't know how significantly reduced it is, but that could effectively kind of allow somebody to, again, if you make it clear in the contract, you make it clear in the fee agreement that you may be doing work for others while you are traveling, and that's why you are you're charging at a reduced fee. That comes down to what we were talking about before, the principle of the notion that just because the client agrees to it doesn't necessarily mean that it's permissible. And I think that's a question that we are struggling with is this permissible? Is it okay to do two things at once, separate things for separate clients, and charge whatever hourly fee you've come out there or agreed to? And how do we write that in a way that folks won't effectively take advantage of that? They'll use common sense. I think we were talking about before, like a lot of this is judgment. It's personal judgment. It's making sure that, folks just don't go overboard, but you can't really legislate that. So anyway, that's I think that's another option, just to clarify, like you said, that it's possible. It sounds like your answer would be to number two: can you bill for travel while simultaneously billing for legal services? Yes, but it has to be set out. It has to be set out in the fee agreement, and it cannot be clearly excessive. To wit, the travel services or the billing or rate for travel services must be reduced. I don't know what language we want to use there, but they must be just kind of reduced compared to your hourly rate for legal services.
Yeah, I'm thinking the travel fee almost is like the steerage fee. It's the cost of getting the body from Charlotte to Timbuktu. I mean, if you go so far down the path, you can say, well, corporate entity A paid for my airplane ticket, so no, I need to take the 10-minute period of that fee of the airplane ticket and apportion it the travel cost of the other client. So I'm just looking at like you said, a practical matter of saying it's the fee of me basically not doing work for you, but just getting my body to you wherever you are, whatever that fee is. And if you follow language, what is clearly excessive, what is fair, that I think solves a lot of the issues. And then you allow the quid pro quo, if you will, between the client and the attorney, and at least open it up for the conversation so that it isn't this, oh my, I can't believe y'all were doing this whole time, and I want to file bar agreements now on you, and or have DOJ, U.S. Attorney's Office, look at you. I don't know, maybe that's a solution. Maybe y'all think it's naive. I don't know.
Yeah, well, no, and that's, I think one of the other things that it's kind of a counter to what we're talking about, and really, I think, supporting the original conclusion that's kind of dancing in my head is the purpose of the travel fee is to compensate the lawyer for the inconvenience of being away from the office, of not being able to work, etc. And so that's where it was kind of hey, I'm not doing legal services for you, but I'm going to get paid an hourly rate because I'm basically, it's almost like I'm off the market while I travel. back in the 90s, you were, you were not bringing your word processor on the plane, or you didn't. If maybe you were one of the lucky ones that had one of those cell phones, but you're paying out the wazoo to actually connect it. And so it was truly a convenience fee, and kind of the fact that you are taken out of your office and you can't do anything. So I'm going to get compensated in some way, not to mention just the inconvenience of being away from my home and so forth. But now you can work anywhere. You can work in your car. You can work on the plane. Your office is in the palm of your hand, literally, with one of these smartphones. And so so I think that aspect kind of lends towards a more bright line. No, you can't double bill, because you're not the purpose of a travel fee. If you are truly doing work, you're getting paid for really an inconvenience that no longer exists. And so I don't know if that lends to any sort of argument one way or the other, but I feel like, again, as we try to wrestle with this issue, thinking about it, I've been trying to think about it from all different angles, and that one is kind of sticking out to me. The purpose of the travel fee is kind of it's kind of moot at this point in society. And there's an argument for travel fees to, maybe be limited to the logistical requirements of actually getting on that plane, spending that money on gas and mileage, whatever it may be. And if you choose not to do work, and you say, I'm not going to do work during this because I want my mind right for when I get to where I'm supposed to get for you, maybe that is something that can be compensated. But if I'm getting paid to travel, which is going to be something that's very convenient now because I basically haven't even left my office, but now I'm ready to do work for you in this other town, there's an argument that travel fee has become clearly excessive. I don't know that I'm a think out loud person. I'm not advocating that position. I'm just kind of trying to throw these different ideas out as we try to wrestle with it.
I'd like to ask a question to the group. We've talked about the various options out there, scrapping this second inquiry or scrapping the opinion together. Is there anybody that agrees or thinks that we should scrap, not publish an opinion at all on any of these inquiries, so we can eliminate that as an option? I mean, do we all agree that at least the first inquiry needs that we should respond to it?
Yes.
Yes.
Um,
I also would add, Davis, that I also think that we should definitely do number 3 corresponding to number 1, because that gives number 1 context and balance.
I agree, and include language about flat fees in the opinion and the these smaller incremental units.
Yes.
Okay, good. So maybe we could move number 3 to number 2 and have those 2, and that way the lengthy more common, that way they're back to back and people can have context when they're reading it. And then the third opinion, it sounds like we certainly need to keep thinking about that.
Yeah. Can I ask the group where, if anywhere, do you lean in number 2? Is there anybody that still thinks that the original analysis, that's just a blanket no, absolutely not, is that the way to go? Or should we tweak this to recognize that travel and legal services can be provided at the same time, and it's either I guess it's kind of a version of the original one. It has to be prorated, but being very clear that it's not even so much prorated as much as you need to offer travel at a reduced rate and make it very clear that you will be doing additional work for clients in your fee agreement, or that you can do that, or it's just a straight up permission, because travel and legal services they're just different, and you can accomplish both at the same time without any detrimental impact to your client. Where are we leaning, if anywhere? And what I'm asking that for, because I think this clearly still needs to be vetted, and I want to put something on paper. And I could draft all 3 opinions. Try to give you 3 different options to answer number 2, and you can see which one feels the best. I think sometimes we get a better sense when we see it in writing. I'm happy to do that to move us in that direction, but I don't know if we had a collective feel towards one of the solutions.
I mean, my personal feeling, if I'm just thinking personally, I lean towards the original opinion more than anything. But I think that putting it in writing is going to be very tough, and it's going to create a lot of issues. And so it makes me lean towards more not addressing it at all, and wanting, and maybe putting something in issue, and maybe adding something to the analysis for issue 1 that kind of addresses it. I don't know.
I'll jump in here. I started the call and sort of, Brian, you laying out the options and the alternatives and the points and the counterpoints on the fence. And I still may be somewhat on the fence, but where I ultimately come down, I think where I'm leaning is we do address number 2 the best we can. And I think the reason for that is we talk a lot about the insurance adjusters and insurance companies. Well, they're sophisticated parties. For the most part, they can handle their business. Where I come down on this is my average Johnson County brethren. If you told them, can you charge 2 hours of work, 1 hour to each client for only 1 hour's worth of time, they would think I'm crazy. I mean, I think that most people in the general public would say, so you're telling me, Lamar, that you now have more than 24 hours in your day or more than 8 hours in your workday or whatever. That don't make any sense to me. So I understand that it's a difficult question to answer, but ultimately where I lean is what you said earlier, Brian, that just because it's a difficult question to answer and just because some people may be upset with the way we answer it doesn't mean that it's not our duty to still answer it if it is a problem or if it is an issue we should address. And the fact that we've been debating this and wrestling it back and forth, and the fact that Jack's got all his buddies hitting him up, telling him what to do or not to do, and the state bar apparently has as well, tells me that it is an issue that needs to be addressed because people have differing views on and even strong views on what should or shouldn't happen. So I think we do our best to address it. Putting different alternatives on paper may make sense. I'm much better at looking at my briefs and things that on paper versus just sort of dictating it to see if it looks good or not. And Bill took my sort of the words out of my mouth, talking about, well, travel expense can be something other than, for legal services rendered. I mean, we charge clients, it's a little bit different, but we charge clients for things all the time that are not legal services. We're reimbursed for copy costs, we're reimbursed for our time using LexisNexis or whatever, or you're using our own video camera in depositions. We have a charge for that. Where I think I've struggled a little bit more is with this idea of a reduced rate, but it's still an hourly rate for travel. Maybe based on the circumstances, that's not clearly excessive. But if you're charging for an hourly rate, meaning you are in fact charging based upon the amount of time that you're doing something, then I have a hard time reconciling that with it being something other than, we call it something like a convenience fee. I heard one of you say that. Well, is it a convenience fee if you're still charging an hourly rate for it? Because convenience fee to me is something that's, if you use in other contexts, it's like a flat fee, really. It's not based on how long. Maybe you hop on a plane expecting to have a short 1 hour layover and, half a day gone, and you end up with delays and cancellations, and suddenly it's a 2-day thing. So I'm processing out loud, Brian, like you are, but I think we do it. I think we try to do it, put it on paper the best we can. I think we need to do it. I think that within that explanation, and Brian, you're very good with words, but just capturing the concept of whether it's for legal services rendered or whether it's for travel expense, What's clearly excessive depends upon the facts, depends upon the situation. Maybe it is different when you're dealing with an insurance company versus your average Joe or Jane. And that it does need to be in any event clearly explained to them. But that in any event, it's probably not okay to charge the same thing you charge for legal services, because after all, hot shots like Jack aren't charging $1,000 an hour just for his presence on an airplane, right? Charging that because of what's up here and his knowledge and his abilities legally, legal services. So I think there does need to be some emphasis that it's probably a reduced rate, because it's reflecting the fact that you're not providing that value add that you are when you're charging your full hourly rate for legal services. You're charging for your presence instead. Anyway, my rambling thoughts.
I should add at that point, by the way, funny, but I have never had a client that pays full rate for travel. They always pay about half rate. And if the rate is a lot, or the rate is, however, whatever the deal is with the client for the hourly rate, I've never, and I don't know anyone who gets a full rate for travel. I think everybody, speaking for myself, the average I think has always been half rate. Now, in the early days, going to Brian's point, it wasn't based on the idea that they anticipated me having a FaceTime with another client while driving, because there was no such thing as FaceTime. It was just, dude, you're driving. You're going to be listening to tunes anyway. So, whatever, we're not getting your full brain power. Although it's a lie, isn't it? Because as you also pointed out, my area of practice, by the way, is down east. So whether I'm going to Sampson County, Duplin County, Onslow County, the whole drive down, I'm practicing my argument. I'm going over the cases over and over. They're probably getting quadruple time as it is. But so I do want to say that I think just the whole idea of the travel time, I don't think there's anyone out there, not anyone I know, who's charging, whether it's some local mom and pop grocery store here in Raleigh or GM. I don't think anyone's billing full time for sitting on an airplane or driving their car. But as a person that drives a lot, because I go to all these counties to argue my cases, right? That same client who might be initially offended by the idea of multiple billing situations going on in the 21st century, in 2023, would be aghast if I didn't take their call while I was driving in the phone for another client, right? Like they would be like, what do you mean you couldn't take it? Well, I gotta get, I mean, I'm on the phone all the time because I drive to all these counties, because that's my practice. I'm always on the phone. I never text though. Not that I would admit on this live stream. Never text. But anyway, this is fodder. Obviously, we're close to the end of the day here. But I agree with Amar's point there that if we want to go down two, it will take a lot of thinking through. But I'm definitely down with doing current one as one, current three as two, and then as a balance as a package, and then whatever we want to do on two. But
I think, Jack, I gotta say I think you hit something that has been in my head that I didn't articulate well, but it's this notion that client expectations have changed because society has changed. I called you. Why couldn't you take my call? We don't want to put the profession in a position to be irrelevant, and say, well, I'm not allowed to take your call unless I go, pull off to the side of the road, start writing down exactly how much time I'm spending talking to you, and while also noting this is the time that I'm now taking away from travel. So then afterwards, I have to go back and create this record of how much were you billed and why your bill was reduced in part for those 25 minutes, and all that kind of. Versus which could motivate a lawyer to say, I'll call them when I get there. well, you're 2 hours too late. Well, I was driving and it makes it, the bar rules make it more complicated for me to take a call while I'm driving. The rules of professional conduct are not meant to necessarily get in the way of lawyers doing their thing, providing services to clients. These rules are supposed to be rules of reason. And so I think in putting that reason in place, it takes into account what society is and the expectations of the client base in 2023. So I appreciate you saying that. I think that's at play here. So anyway, I know we're drawing towards, we've got 10 minutes left. I don't know if anybody else has thoughts. It sounds like we're all kind of circling. Oh, Catherine, yes.
Well, I don't think I'm going to say anything profound. I mean, I could support anybody's position in a way, but is it possible to, because Lamar made a great point about protecting the public, is it possible, and I agree with the switching of the numbers, but to the old number 2, to basically, instead of saying no, say it depends? Because the way we protect the public is what's in your fee contract. And so to the extent that things are covered in your fee contract, that may be box 1, but then you also have, you can't be dishonest or clearly excessive. And that, you know, we're not necessarily going to say that you can or can't do something. We're just going to say, here's the analysis, which is what's in your fee contract. And then, you know, have you been dishonest or is anything clearly excessive? Because one thing I thought about is, what are the other things that we often do besides, you know, while we're billing, you know, while we're talking on the phone or do whatever. And I thought, what about the situation where, like, my paralegal is billing for her time, she's making copies. She's billing, and we don't bill for copies, but let's just say we did. Does that mean, you know, those are 2 different things. And why can't the same apply to a lawyer? If I'm back there making copies and I billed for copies, can I do that and also bill for my time talking to a client on the phone? I mean, again, I think that's reasonable. And that's why I kind of go back to number 2 and say, is it possible that we could just keep it very simple and say, ultimately, it depends? You know, because what's in your fee contract is part of the analysis, but then have you been dishonest or is it clearly excessive? To me, that setting that framework is more helpful, because then people can kind of establish what's appropriate for wherever they are and however they practice. But ultimately, the way we protect the public, the best is having it in the fee contract. I mean, then they know what they're signing on for. And then let's say that it wasn't in there or it was in there, there still is the threshold of, were you dishonest or was it clearly excessive? And so is it possible to not give a definitive answer, but say, this is how this issue would be analyzed?
I think so. I think that's the it depends things. It puts, well, the opinion would just need to be really clear on what the analysis is, because when I think anytime that we've answered something with "it depends," it does open the opportunity for folks to interpret and misinterpret, and particularly when it comes down to, you know, my former life down in front of the DHC, when, you know, folks might argue, well, this ethics opinion says I can do this, and where everyone else is screaming, no, 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 you know, that's clearly excessive. I didn't know that. It said it depends. So that is my, I generally have a kind of a sometimes, oh, do we really want to say that? But in this situation, I think you're right. Your thought process, and I think is what we're all kind of circling around, that there are reasons when, or there are times when this would be seen as really kind of a, I guess, inoffensive, certainly not an unethical thing. And then there are times that it would. And so trying to figure that out, and like you said, the fee contract being a key part, but not determinative, because you can't just, you know, say, well, the client agreed to it, so therefore it's okay. Like, well, that's not the end of the question. We have standards. So I think I mean, this is all good feedback. I know we're still kind of, I feel like we're still kind of hanging out in the ether, right? We're trying to figure out exactly what it is. And I want to take a chance to write some opinions. And I say opinions plural because I think it'd be good to see a couple of different options on paper. But I want to kind of start off with what you said, Catherine, and then kind of let it morph. And we can see there may be some that we see on paper and we go, oh, not no, but hell no. Like that's just not going to be okay. And that will be helpful. So, Davis, if that's all right with you, I think maybe we can make the report next week and essentially, have it stay in subcommittee. Say, we've got 2 inquiries and opinions that we feel good about, but this last one, we are still trying to figure out the best analysis that properly balances our duty to protect the public while also providing a practical and reasonable pathway for lawyers to practice in 2023. It's not as straightforward of a question as I think it was when the ABA issued its opinion in 1993. So we'll just kind of continue to mull this over.
I think that's a good idea. And just a heads up, my trial for Wilmington did not settle, but it got pushed because of some trial conflict with one of the other attorneys. So that's being moved to March. So I'll be there next week.
All right. That's right. I forgot you were originally gonna potentially miss it. So, but now you're back.
Yeah.
Fantastic.
Just found out last night. So.
Just don't double bill for your trial prep, Davis.
Yeah.
Yeah.
All right.
I think this was productive, and I think it'll allow us to have some meaningful discussion at the committee meeting on it. So
yeah,
we can take that feedback again. And
yeah, I guess that'll be the we'll have to see what the chair of the ethics committee wants to do. If she wants to rein us all in, or if she wants to just let us roll
right.
for the next 4 hours there. So
that's right.
We'll see. She's a loose cannon, from what I understand.
Maybe. Depends what my mood is. I still want to beat David Allen's record, but I have a feeling we're going to have a lively debate about whether or not we can all be referred to as doctors. I'm just going to say it.
All right. Well, Doctors Armstrong, Fry, Lloyd, Poisson, and Powers. It's I shouldn't be saying this on a live stream. I'm sorry, but nevertheless, we'll have that debate next week. Davis, is there anything else that you want to discuss, or should we adjourn for the day?
I think we're good to adjourn. Good seeing everyone.
Great.